Okay, good afternoon and happy Pro Bono Month. I'm Alex Rogers. I'm the Director of Programs at the North Carolina Bar Foundation, and we're excited to be here today with our NCBA Sports and Entertainment Law section to talk about their Student Athlete Pro Bono project. Joining us today is Barbara Osborne, who has been coordinating this project from the start, and she is going to provide training on the project. Barbara has asked if you have questions, you can ask those questions throughout the presentation in the chat. We will be monitoring the chat and alerting Barbara as questions come up. So do feel free to ask those questions throughout today's presentation. Barbara?
Thank you so much. Hello, everyone. Thank you all for your interest in the NIL Pro Bono project and for joining us on Zoom today for training. As Alex introduced me, I'm Barbara Osborne, co-chair of the NCBA Sport and Entertainment Law Section's Pro Bono Committee. I'm also a sport law professor at UNC with a joint appointment in exercise and sports science and at the law school. And before I came to UNC, I worked in college athletics for 16 years. And way before that, I was a student athlete. So legal issues in college athletics is definitely my passion. Okay, and we'll see if, and the slide is not advancing. So this is interesting. There we go. Okay, always something, right? So on July 1st, 2021, the NCAA revoked all rules prohibiting student athletes from profiting from their name, image, and likeness, which we'll call NIL, dramatically changing the intercollegiate sports landscape. This announcement provided almost no guidance to student athletes or schools other than that they were supposed to comply with the law of their state or follow the policies and procedures established by their athletics department if their state didn't have a law. So at UNC, the Athletics Compliance Office put a committee together to brainstorm ideas to be able to connect student athletes with legal advice for their impending NIL opportunities without breaking any of the NCAA's extra benefits rules. So that basically meant that any service the school provides must be available to all students in order for the school not to have that type of liability. So I reached out to Neil Magnuson, who was chair for the section, with an idea for a pro bono project to connect student athletes with sport and entertainment law attorneys from our section for free legal advice for their NIL contracts. About 20 attorneys from the section and 30 law students signed up to provide document review and counsel, but instead of the mad rush of student athletes we were expecting, there was one student athlete that contacted us the first year. Although there were 2 performance students and 1 social media influencer from the general student population. So we didn't have to worry about violating any NCAA rules. Last year, we tripled our service. Yes, a grand total of 3 athletes. But in August of this year, right before the school year started, there were 5 athletes who sought legal advice. So we were hopeful that there would be more need for our services. However, since classes have started, there hasn't been anyone. So the section leaders discussed expanding the project with the blessing of the NCBA and the NCBA Foundation, and we have. So let's get started with the training. Because student athletes are generally supposed to report all NIL deals to their compliance office for a cursory check to see if the deal would violate any NCAA rules or institutional rules, we reached out to the compliance offices at the D1 athletics departments in North Carolina to tell them about the project and offer our pro bono services. Compliance would then share our pro bono project information to provide free legal advice before athletes enter and encourage them to use it before they enter into any agreements. The student athlete would then send the contract and their contact information to our NIL pro bono project email address. An alert will come to me, and depending on the student athlete's school, I will either connect them with a law student for a first look or connect them directly with an attorney. The key to working with Gen Z student athletes, we've discovered, is immediate response. They have absolutely no patience, and I know that in your legal practice, clients generally have to have a lot of patience. But Gen Z isn't really big on the patience scale. So I will reach out to the volunteers on this list. Again, if it's students, I'll send it to them, but I'll also reach out to the attorneys to either connect a law student with the attorney or to connect the student athlete directly with the attorney. And ideally, if you can at least make contact with the student athlete to acknowledge that they've got the contract within 24 hours, and then hopefully you'd be able to go through things with them within the next 24 hours after that. The final step then, after you've connected with the athlete, is to just send an email back to me or through the portal saying that the review was completed. Now, things to remember is that you aren't giving legal advice generally about something, whether something's a good deal or a bad deal, as much as you're giving advice about what the details of the contract mean, what the legal obligations and liabilities might be. So that's kind of like telling them what a bad deal is. You could suggest different wording for various clauses, but you aren't representing the athlete in a negotiation. And then for all pro bono things, you're also not soliciting clients. Now, because you have expressed an interest in volunteering for this project, I'm going to assume that you do have some understanding of name, image, and likeness. But again, if you have any questions, please submit them in the chat. The professor in me always starts with fundamentals. So here on the screen is a definition of the right of publicity, which is the legal foundation of name, image, and likeness. So the right of publicity generally comes from the right of an individual, especially a public figure or celebrity, to control the commercial value or exploitation of his or her name and picture or likeness, and to prevent others from unfairly appropriating this value for commercial benefit. Now, in a recent NIL overview, Open Doors, which is one of the major platforms that connects student athletes with companies and organizations that want to provide student athletes with NIL opportunities, it was reported that 80% or more of NIL deals are coming from collectives. Now, as many of these deals do not appear to have anything to do with actual name, image, or likeness, particularly if you use the definition we use, the NCAA issued an additional interim policy guidance regarding third-party NIL involvement with student athletes. The policy reminds NCAA members about the definition of a booster, reminds schools that they cannot be involved in recruiting, and therefore cannot use NIL agreements to induce athletes to attend specific institutions. And institutions are reminded that they're not to arrange for student athletes to meet with boosters or collectives, nor are they allowed to communicate on behalf of the booster or collective to a student athlete. So I've included these NCAA rules in here, even though they're not the law, so that you have an understanding of where this all fits in relative to the potential for student athletes jeopardizing their eligibility. Now, in the meantime, again, the, oh, I'm sorry. Did I have those two slides backwards? All right, the interim policy we talked about, all right. The collectives, the NCAA has deferred to state laws. All right, here we go. Sorry about that. The NCAA has deferred to state laws. Various states have written into their laws allowing the booster behavior and other behaviors. None of those are our state, so we are only beholden to NC Executive Order 223, which was issued on July 2nd, 2021. And this basically states that student athletes enrolled in North Carolina colleges or universities are permitted to earn compensation and obtain representation for use of their NIL. Now, it says while enrolled at the institution. So they're only concerned about current student athletes. They're not concerned about what happens to them afterwards. And that by doing so, athletes will not, their scholarships or their eligibility won't be in jeopardy, but our executive order does issue some conditions. So student athletes cannot enter into contracts or receive NIL compensation as an inducement to enroll or continue enrollment at the institution, or as compensation for performance, participation, or service in an intercollegiate sport. So that's very, very consistent with all of the NCAA rules. The student athlete representative needs to also comply with the NC Athlete Agent Act and SPARTA. So anyone who is presenting a representation agreement should also be registered in North Carolina and beholden to the rules of the federal legislation, SPARTA. Institutions themselves cannot compensate student athletes for their NIL. That's very different than some state laws. Missouri is quite brazen in what they're allowing state institutions to do. Now, it also provides some safeguards for institutions. Institutions can prohibit student athletes from entering into contracts that conflict with contracts of the institution. They can impose reasonable limitations or exclusions on products or brand categories, which is why it's so important for student athletes here in North Carolina to bring their proposed NIL deals to the compliance office first, because they would have the best information about what school brands, et cetera, might be conflicts. Schools can limit student athlete NIL activities during official team or institution sponsored events. I know that UNC does not allow athletes to record anything for NIL purposes during practices, games, or team events. They can establish procedures for ascertaining that student athletes' NIL use is related to their fair market value, which calls into question what a lot of collectives are using to attract student athletes. And it can limit student athlete NIL use of intellectual property, institutional intellectual property, and whether or not athletes can wear their team gear or equipment bearing their school logo, et cetera. And then all schools are supposed to establish reasonable rules so that student athletes have notice of what is expected for disclosure related to their NIL compensation and contracts. So that's sort of the rules and the legal landscape that we're in North Carolina. So the typical student athlete NIL contract scenarios are a social media endorsement. We'll get into that a little bit more. Sponsorship or personal appearances. And this would also include contracts with collectives and marketing representation agreements. So for our pro bono services, the student athlete has typically asked for help with a social media endorsement or a sponsorship personal appearance, but there's also been marketing representation agreements and one law firm / sponsorship combined contract that was very interesting. So for our pro bono services, the student athlete is going to be likely to need you to go through the document with them, explain the language that they're unfamiliar with, and explain the meaning of various clauses. So although I know that you are all familiar with these terms, either from school or from practice, but these are words that student athletes are not very familiar with, especially in understanding what the legal meaning of these things are. And they also will not have a complete legal understanding of the implications of those terms. So these are words that you should be looking out for to be able to explain to student athletes what the impact of these words are and what their obligations are under the contract. So the first thing, obviously, Basic Contracts 101, is whatever document you're looking at If there's a header or a label that identifies the intent of the document, that might need to be explained as well. Now, endorsements, student athletes promoting or advocating for a business or product, in kind, payment in goods and services as opposed to money. There are lots and lots of in-kind agreements. And when we get to some of the clauses, there are some implications that student athletes are definitely not familiar with. The word irrevocable, understanding that this can't be changed, reversed, or recovered, revoked in any way. It's absolute and final. So most of them don't understand that at all. There are licensing agreements. They really don't understand licensing. They don't understand sub-licensing. And a lot of these contracts basically give, the athlete is giving up their right to everything forever, which comes to perpetuity. And they're also giving that sponsor the right to transfer that right to others, to license it, to sub-license it. And because it's irrevocable, it can never be changed. So some of the common clauses, the exclusivity clause, because student athletes and this entire generation basically, and maybe a lot of us too, are so used to just looking at something on a screen and clicking, even though we don't bother to read anything that we agree to. They don't really understand that agreeing to do something with clicks does create a contract. And if there's an exclusivity clause in there, they can't promote competitor products or services. And if they're just clicking everything that comes in front of them, many of them are violating this. Force majeure clauses typically will come if a student athlete is doing personal appearances. Indemnification clauses are sometimes in there, not too often, but student athletes definitely don't understand the whole concept of indemnification. Now, liquidated damages, when there are liquidated damages clauses, and I've seen a few where the student athlete would have to pay an amount in liquidated damages. Ideally, you would want to see a reciprocal liquidated damages clause. So if the other party breaches their contract, they would still have to pay the student athlete. The endorsement clauses, the endorsement contracts very often include morals clauses. And so those are something for student athletes to be aware of as well, as far as what the expectations for their behavior might be, because something that they just think is funny or harmless might be something that would seriously object to. So termination clauses, obviously they need to understand what they need to do in order to be able to terminate a contract, as well as what happens when that contract is terminated. The right of first refusal offer, typically that's only in sort of larger endorsement agreements. I haven't seen it in any of the smaller social media ones, but I have seen arbitration clauses in contracts requiring any disputes regarding the contract to be arbitrated instead of filing a lawsuit in court. But for those that don't include arbitration clauses, the choice of law, choice of venue, I've seen all of the contracts I've looked at have been athletes that are in North Carolina, and I have seen choice of law in several other states already. So explaining that to an athlete and suggesting that maybe they want to change that to here for their convenience would be better. Severability clauses are obviously normal, and but again, athletes don't typically understand what that means. And so let's get into examples from some of the contracts. So I have sanitized these to protect the rights of the people who first made these offers to student athletes. So I'm calling this the Team Donut Shop offer, but it could have come from any kind of food establishment or even shops. You know, think about Franklin Street in Chapel Hill, where you have all sorts of gear and things like that. So as you can kind of look through the words here, the first thing you see is that this offer, this offer actually came through an email. And it was one of those ones where you just click for agreement, basically. And so the email was addressed to all UNC Division I athletes. Okay. And it had a few paragraphs that provided a brief introduction to that local business, and then a lot of praise and respect for the athlete's contribution to the university and the community. Now, obviously, this is a unilateral contract. It's essentially an offer that the student athlete accepts by doing the things that are required, right? So basically, they're saying, you're going to have to do this stuff and then come by and we'll give you this stuff. So the first thing they want you to do is announce your participation on social media. And here they're saying, don't wear school clothing or paraphernalia, because they're at least aware that the school, they would have to get, you know, student athletes would have to get permission for that. So they're just avoiding it. So once you announce your participation, then you have to come by the shop, and then they're going to give you a gift card and or swag. So the and or doesn't mean you get a gift card. Doesn't mean you only get swag. You've already had to do social media posts. So if all you're getting is a t-shirt, maybe this is not worth it to even bother to go to the shop, right? So the language is really vague here. You agree to have a photo taken, and that photo would be posted on social media. Well, what social media? How often on social media? Wear your Team Donut Shop gear around campus. Well, how are they going to know that you're doing that? Okay. Next, it gets a little dicier, right? It says, we'll let you know about special events happening at the shop, and you will be required to repost these on your social media. Well, how many events? How often are you required to post these things? And then it says you're agreeing to proactively represent the shop. Again, really general words. So additional activities to support would be regularly visiting. Does that mean you just have to pop in, say hi, or does that mean they expect you to buy stuff or take pictures or do other things? Add Team Donut Shop to your Instagram bio, share Instagram stories on your page, and help out at events. Like, how many times do you have to stop by? How many events do you have to attend? How long are these events? When are they? Are they happening at times that you have practice or games? You don't know any of these things. So if you're interested, just click on the link below and fill out the form. And then by submitting the form, you agreed to abide by the understanding outlined above, which basically told you almost nothing. And we'll be in touch regarding next steps. So super happy Team Donut Shop offer, right? But really maybe not a good deal, or maybe a fantastic deal for somebody who doesn't have any other opportunities and really, really loves donuts, right? So another example from a contract, this one was a shoe company endorsement. This was not an athletic shoe company. It was a casual shoe company. And it came in the form of an email, and then like each header within the contract was on a different screen. So the athlete basically had to sign in. The invitation had a link. They had to sign in with the ID and password that was provided in order to even see the terms of the agreement. And then they had to basically do a screenshot of every single page and copy that out in order for anyone to be able to review it. Otherwise, unless you're actually there with the athlete in person to go through all of that for the first time, that's what they would have to do typically to send stuff to us. And then the other thing is that, of course, when the instructions that say to provide their link, that this offer is only for them and they're not to share it with anybody else, and no one else is supposed to see it. So the offer itself is kind of discouraging them from getting any legal advice on this contract. So this is the Compensation Commission product step 1 screen. It says you'll be paid by commission and with products. So there is monetary commission as well as in kind. It says you'll be paid 15% commission for each purchase made with your affiliate link. But what it doesn't say is 15% commission of what? 15% commission of their profit, 15% on the sale of the item. So this is something that, again, is vague and is not clarified, and the student athlete might think one thing and you might think another. So then the link is provided for them to share that. And it says that you'll receive a pair of shoes. So you get a pair of this product just for participating. So you know that you're going to get a pair of shoes and you might get something on commission, but even though it says 15%, you don't know if that's going to end up being pennies or dollars. So then I skipped one of the pages, but this is the step 3, which explains the tasks they're required to complete. So here they want you to use hashtags related to their brand name, wearing their brand name, and promoting their social media accounts at brand name. They expect 2 Instagram story posts, and then there's a little drop-down menu that explains what needs to be in every story. And one Instagram post or video with a drop-down that's explained there. But what it doesn't explain is that with all of these hashtags and stuff, you need to do the hashtag ad, etc. stuff, but we'll get to that. This is step 7, where it says you have to agree to these rights that you're granting shoe company, and here's where it gets fun, right? Worldwide, irrevocable, royalty-free, fully paid up, transferable, sublicensable, and perpetual right and license to reproduce, publish, distribute, display, repost, share, and edit all content created for or on behalf of the company in any and all media now known or developed in the future, including the right to create derivative works, which includes but is not limited to, and then it gives a list of 8 different things. So again, well, going back here, if this athlete does this their junior, senior year, they're basically granting all of these rights forever. What if you go on to a pro contract? What if you go on to national team or international glory in an individual performer sport? This company is going to be able to use your stuff forever, right? And so athletes need to understand the consequences of that. And again, by explaining all the things that the athlete is giving up, they're only getting guaranteed 1 pair of casual shoes. So does that seem like a fair agreement? Now, are there terms that a student athlete would like to try to negotiate? Again, you're not expected to negotiate on their behalf, but if they ask you for suggestions on ways to change wording or something, that's totally fine. Now, I mentioned the FTC. So for social media endorsements, it needs to be obvious to the consumer that there's a relationship with the brand. So athletes are expected to disclose any financial, employment, personal, or familial connection. The easiest thing to do there is just post hashtag ad as the very first thing after their post before any of those other hashtags or addresses. Okay, so when you superimpose hashtag ad, you need to superimpose hashtag ad on Snapchat, Instagram, or Facebook story photos or videos. So not just in any narrative. You should verbally disclose the relationship at the beginning of a live stream. All right, so that it's clear that even though you really truly do love this, that you're doing it because you're representing that company. The FTC does offer Social Media 101 for Influencers guide, and that is actually a hyperlink that if you look at this presentation later on, you can get to that. We need to remind student athletes that they need to be truthful in any endorsement to avoid false claims, because if they're caught on, video talking bad about a company that they represent or something like that, obviously this is going to be a problem. Deceptive advertising is also an issue. So under FTC Act Section 5A, an act is deceptive if it misleads consumers and affects consumers' behaviors or decisions about a product or services. And it's unfair if it causes or is likely to cause, if it's substantial, not outweighed by other benefits, and not reasonably avoidable. So going to some of the marketing representation agreements. Now here, this agreement is formed between the representation company and the client, which is a student athlete. So they, again, are saying we have exclusive worldwide rights to negotiate all contracts on behalf of the client. Okay, so exclusive worldwide, really? This is a student athlete in the United States, and you're negotiating all contracts. So just marketing contracts? No, this says all contracts. So personality management. So if they have media negotiations, personal appearance bookings, commercial representation for endorsements, for NIL, they want to represent it all. It does say that the student athlete will have final approval of all contractual terms, but the company will not enter into contract without the athlete's advance consent. Although not in this particular contract, but I have seen contracts where they actually ask for the athlete's power of attorney. So then the athlete would not have to be giving consent. So here it gets fun because they talking about fees. For all these contracts, they're going to get a commission of 20%. And this 20% is regardless of whether they continue to represent them during, for the duration. And that's normal, because if you negotiate it, then you get your percentage for the length of that sponsorship, right? But athletes need to understand that even if you go to somebody else, that first person's going to be paid for this stuff. So in connection with outside sponsorship, advertising, or endorsements, they will get the commission for anything that they arrange or negotiate. So their shoe deals, internet deals, and appearances, okay? And then if those things are in kind, they're going to end up getting that percentage of whatever it's equal to, all right? Now, I have seen other contracts where they get a percentage, whether the athlete gives them, whether they negotiate the deal for the athlete or not, all right? And so here it says the client agrees to notify and consult with the company prior to entering into any commercial endorsement or marketing agreements that they did not arrange for. And I'm guessing that's because if you notify them beforehand, then they want to step in and negotiate this for you so that they can get their percentage. So in the term, best practices, according to the NCAA, would be only to have student athletes enter into terms for the remainder of their athletic eligibility. This contract asks for a period of 2 years, and then it also says it's going to be automatically renewed for successive 1-year periods unless it's terminated in writing with notice for 60 days. Okay. So this is this is an athlete that's probably going to have a professional career and they want to get in on the ground, and they're planning to ride this commission for a long time. So assignment of the contract, though, they basically say that we can assign your contract to anybody else. So they're looking at, maybe my firm will get sold, transferred, or merged, or acquired, or something else. So we're going to make sure that you, as a valuable client, are able to be transferred along with whatever we sell the company for. Athletes don't understand when they think they have somebody representing them. They don't understand that that person representing them might not continue to represent them, although the contract will continue. The client warranties and representations. They say the client warrants that they're free to enter into the contract, that they haven't been, that they're not currently under contract with anybody else. But it doesn't say that the client has been informed that they're entitled to legal counsel before entering, or encouraged to get counsel before entering into an agreement. And then again, this is one that, although this particular contract was with an athlete that was in North Carolina, this is governing law for DC. And it also has an arbitration clause in there. So some of the other things that an athlete might need to be informed about relative to their agreement, even if it's not in the actual agreement, is a reminder that they need to get permission at minimum from their institution and or the sponsor if they intend to use any of the intellectual property or trademarks or logos. Some of the contracts have had clauses that say which sponsor logos, et cetera, the athlete is allowed to use, like in their posts and things, or that they specifically want the athlete to wear specific articles of clothing or whatever that clearly show the logo on it. So those things are okay, but they need to get permission, particularly if they want to use any team or university related clothing. At UNC, they make it really, really easy for the student athletes to get permission because they have a link at the UNC trademark and licensing website that allows them to just connect. As far as taxes, that's another thing, is that student athletes just need to be reminded that for all of their earnings, unless they're being paid a salary that's going to take out taxes, they're going to be responsible independently for paying those taxes, and that they do have to pay cash taxes, even if the only thing that they're getting paid for is in kind. So if that athlete has eaten more than $400 worth of donuts in the year, they're going to have to pay taxes on those donuts. One tip is to refer athletes to VITA programs, which any school with a business school typically has a volunteer income tax assistance program. And so athletes can also take advantage of those services if they qualify. Now, in North Carolina's executive order, it does encourage schools to do education, NIL education for their student athletes, and it does encourage them to also provide intellectual property and accounting and tax education. But that doesn't mean that all of the schools do it, and even if the schools are doing it, it doesn't mean that the student athletes actually voluntarily choose to attend those education sessions. So I've included language from another marketing agreement here. The commission, payment, and expenses are areas that need close scrutiny. Red flags go up in my brain for all of the highlighted sections on the screen. And then also for any agreement that ties the agent marketing or athlete representation, ties it to financial advising, those raise red flags all over the place and have for years. This isn't new to NIL because I've been looking at a lot of representation agreements over the years for student athletes that go on to pro contracts. And so the ones that give a super big discount for representation for initial contract and then take huge percentages for financial advising are particularly onerous for the student athletes. So in this one, all of these highlighted areas basically are, because for this particular agreement, the agent is requiring the student athlete to basically have all designate them for all of their business dealings. So any payment of NIL income goes through the agent. The agent will take its commission first and then will forward remaining income. At least they do promise to keep accurate records, which is the least that they have to do. But for non-cash NIL, it says that they'll divide it 80-20. The 20% share will be delivered to the agent. And if it's a non-divisible, non-cash NIL thing, this is very, very vague language. The parties agree to collaborate in good faith on how and what level the agent should be compensated. So this doesn't say I'm going to take 20% of the value of it in cash from you, which I have seen contracts say, but it says we're going to agree to collaborate. And so I don't know that that's a clause that's actually enforceable. But here, then it also says the agent agrees to pay their own normal expenses. But then they talk about additional expenses incurred specifically on your behalf and with your approval, such as travel. You agree to reimburse the agent, which comes from your income, which goes directly to the agent. Or if it's something that has to be paid, you pay directly. So you buy my airline ticket, etc. I have never, ever seen a contract that asked the athlete to pay the agent's expenses in this way. And I can't even imagine why the athlete would. Anyhow, so that's it for the current contract things that have typically gone on. This slide says, what does the future hold? And I wanted to talk just a little bit about the most secretive NIL document that probably exists is the contract between a student athlete and the collective for the school. It's really, really hard to get a copy of any of those. Many athletes don't sign contracts, or they just sign a contract without getting anybody else to look at it because they believe that the organization that's affiliated with their school is looking out for them, right? Instead of that they're looking out for themselves. So last Friday, Michigan State's Spartan Dogs for Life collective announced that they are voiding contracts with almost all of the Michigan State football players that they had. So they're basically voiding 30 to 35 student athlete contracts. They were only leaving the contracts with the men's basketball team intact. Now, the collective blamed shortage of funds, but I'm guessing that it would be really interesting to look at the termination clause for that agreement and any kind of contingency clauses that might be there. Because without us being able to see their initial contract, it's hard to know if athletes would be able to bring forward a claim of a breach of contract, or if there are clauses in there that allowed them an out if they didn't have the money. It's so anyhow, it's the collective stuff is going to be really, really interesting. It's also going to be interesting to see whether or not athletes will lose eligibility. We have only seen one NIL case go through the NCAA infractions office, and that was related to the University of Miami and a booster. And even though it really, really looked like the booster was directly inducing the Cavinder twins to transfer to the University of Miami for the NIL deals that he would be able to arrange for them there, it was very disappointing that the NCAA did not punish Miami. The NCAA has said that they're not going to directly punish student athletes for NIL mishaps if the university has not properly informed the athletes. But the NCAA also didn't require Miami to dissociate with this particular booster. So it's going to be really interesting to see if athletes in the future do lose eligibility. It's also going to be really, really interesting. There have been more than a dozen bills announced. Some have gone to committee, some have just disappeared. It'll be really interesting to see if there is any federal legislation that is enacted, and whether that's NCAA friendly legislation, whether it's not NCAA friendly, and whether the NCAA would then try to go after them for exceeding the scope of their authority. I don't know. But this is still the wild, wild west. Athletes do need our legal advice, but sadly, we're not being asked to provide it that often. But hopefully, if you get the opportunity to do it, you're going to be in a really, really good position to offer them great advice. So I didn't notice any questions in the chat as we went along, but if you have questions now, I am happy to take them.
I've got a question. So I look at a lot of content creator contracts, and some of that revenue flow through is pretty typical, especially, UTA, CAA. Are the problems here more derived because of the extra regulatory landscape, or just because of the higher potential for abuse? I just wanted to dive a little deeper into that.
Yeah, so it's all of those things, right? It's that student athletes really aren't educated and they don't understand. And it could be that this is very much something that they do want to do. They just need to understand what it is that they're agreeing to, and the words are all foreign to them. And then it's also that unique regulatory nature where they need to know if what they're agreeing to is going to violate NCAA rules, or if it's going to violate our state law. And where it would typically violate would probably be related to those restrictions that the school is allowed to ask for, right? Did that answer the question?
Yeah, that was great. Thanks.
Okay. So, okay. No.
Barbara, I have a question.
Yep.
At the beginning of your presentation, you mentioned that the schools are able to impose certain limitations and restrictions on the students on a school level. So in terms of when attorneys are volunteering and looking over these contracts, are there places where they can reference those limitations or restrictions, or where should they point the students to go to confirm what those limitations are?
Right. So most students will probably learn of us through their compliance office. And so they will have already gone to compliance and compliance will have looked at it and said, do you want legal services? And here's this opportunity, right? But it's not a bad idea to just ask them, you know, did you check with your compliance office if there are any conflicts with any university programs? You know, so I don't think it's your job to have to look up to see what those are as much as it is to just ask them if they've had compliance look at it to see if there are any conflicts. Does that make sense?
Yes, thank you.
Anything else? All right, well, this isn't a CLE, so you don't have to sit out the last 10 minutes to get all your time in. So we can give you 10 minutes left to cram lunch in before you have to go back. Thank you so much, everyone, for coming. And if you have any questions, don't be afraid to reach out to me or Alexa as the chair or Alex for pro bono. We'd all be happy to help you.
Also, just to close it up, Barbara, thank you so much for putting together these materials. It means the world. For those of you that are section members, we do have our next event coming up here on Saturday. I believe there are still tickets. So if you were in the Charlotte area or willing to come down to the Charlotte area, we are having a social down at Charlotte Motor Speedway at the Xfinity race at the Roval. It is a playoff race. So if you are a fan, we'd love to have you out. I believe there's about 10 to 12 tickets left up over.
There was something in the chat that said, will the slides be emailed? I think it can be posted in our section stuff.
Yeah, we can add these up into the sports entertainment sections like library of documents, and then we'll look into other areas for those of you that aren't section members as well.
All right.
Everyone, have a great afternoon.
Thank you.